My name is Jiyae Hwang. I am a senior associate at Scott Legal PC. And today we are going to spend some time talking about the visa options that are available for individuals with extraordinary ability in their fields. Now, before we go on, I'm going to see if we can record this presentation. Oh, it looks like it is already being recorded. Okay, which is perfect. All right, so just a few housekeeping details before we get started. Scott Legal is a full-service immigration law firm, which means we have expertise handling a wide variety of non-immigrant and immigrant visa categories suited for various circumstances. So whatever your immigration needs may be it a family-based, employment-based, or investment-based immigration matter, we can help you find a solution. We will be continuing this webinar series, and we are doing at least 2 webinars a month, and sometimes even more, on different immigration law related topics. And at the end of this webinar, we will be sending out a few things to all participants. First, we will send you a copy of the PowerPoint that will be used in this webinar. Second, we will be sending you a guide, a visa guide, a comprehensive guide that you can use as a resource that covers the visa categories that we will be speaking about today. Finally, we will also send you a link where you can follow and sign up for additional webinars that are coming up in the future, and also a link to this webinar as it will be recorded. This webinar will also be made available on YouTube, and we do encourage you to subscribe to our YouTube channel and hit the notification button, as we do regularly upload a variety of immigration law related videos. Finally, we will send you a link that you can follow to set up a consultation with one of our experienced attorneys should you wish to discuss your case further. So today we're very lucky to have Hugues Plessis, who is a senior associate of the firm with a wealth of experience handling the visa categories that we will be speaking about today, which is related to individuals with extraordinary ability, and we'll be presenting about the various options available and the requirements and considerations. Finally, for any questions you may have, please feel free to add them to the chat box or use the Q&A function, and we will try and get to all questions. So without further delay, let us get started. I'll turn it over to Hugues.
Thank you, Jay. I appreciate it. So we can move on to the first slide. And we're going to just go over what are the extraordinary ability visa categories. We'll go into detail a little bit later on, but for now, we can just go over the overview. I'm just gonna wait for the slide to appear for everyone. Jay, I don't know if you're seeing it on your side.
Hugues, I'm sorry, I don't think I'm hearing your audio. Can you
Oh, can you hear me now?
Can people in the audience hear the audio at this point? Can people put
raise
things
your
in the
hand if you
chat
can
if
hear
you can
me.
hear?
Okay.
Okay,
So
raise
people are
someone's
raising their hands.
hand.
Okay, so sounds like they can hear me.
So people can hear or can't hear?
Yes, they can.
Can't?
Yeah, if you want to type in the chat maybe for GA, because I think I have some issues there, but sounds like everyone can hear me. All right, so let me just if we can move on to the next slide, GA. I don't know if you can hear me now, but right, yeah, everyone's confirming that they can hear me, so it sounds like might be an issue on the GS side. So let me just go over the first few items that we wanted to go through today, and you'll see it on the first slide here in a minute. But essentially, we're gonna talk today about extraordinary ability visas in the US. Would it be non-immigrant visas or immigrant visas, so the green card for when you have project of permanently staying in the US and working in the US, when you have that extraordinary ability component. Oh, there we go. That's the first slide here. Thank you, Jia. So as I was saying, we're going to go through all of those categories today in detail. So the first one here, as you can see, is going to be the O-1A visa. That's a non-immigrant visa for individuals with extraordinary ability in the following fields. So sciences, education, business, or athletics. So that's a very good option if you consider that you are meeting the requirement for extraordinary ability in those fields. And I will go over a little bit later on, what extraordinary ability means and what those criteria are. The standard for the O-1A visa is that the person is one of the small percentage who have risen to the very top of the field of their profession. So it's a very high standard, and you will have to provide, a lot of evidence showing that you are into, that small percentage of people who have risen to the top of the profession and their field. And I will go over what evidence we usually include. But that's it for the O-1A. Then there is the other side of the O-1 visas. There's going to be the O-1B. This is also a non-immigrant visa for individual with extraordinary ability in the arts or extraordinary achievement in motion picture, television industry. So you can see here different fields. The standard for the arts a little bit different as well than the standard for sciences, education, business, or athletics. And it's going to be that the person must have received a distinction, so a high level of achievement or extraordinary evidence by a degree or skill or conditions substantially above that ordinary accounted for the extent that the person is described as prominent, leading or well-known in the field of arts. So that's the standard there. I will go over it a little bit later on as well and what it means. And then standard for motion picture, television industry, sort of a rather niche area if you're in, but very interesting. The standard here is higher. An applicant should prepare to show that they have reached a level of acclaim substantially above that of his or her peers in the field, of motion picture and television industry. So those are the standards that for the O-1B, again, different from the O-1A, and the evidence that you will have to provide are going to be different as well. And I'll go over that a little bit later on. So for the O-1B specifically, just a quick note is that the standard is slightly lower than for the O-1A. If it isn't clear whether or not you qualify under the O-1A, if you are in a field that could be qualifying you for both the O-1A and the O-1B, for example, a tattoo artist or a sommelier, or someone who's gained preeminence in the business field, but also maybe in the arts, then you might want to speak with your lawyer and may want to apply for an O-1B instead of an O-1A if you believe that the evidence that you're going to bring to the table may not be sufficient to satisfy the standard of the O-1A, which is pretty strict, and rather you want to meet the standard for the O-1B, which again is slightly lower than the one for the O-1A. So there's a little bit of strategy involved there. And then the EB-1A green card, so that's the other side of the extraordinary ability visa categories, and that's for a green card, so it's permanent residency in the US. That's when you have a project of staying permanently in the US, work in the US, and have your residence there. So this is for individual with extraordinary ability as well, and there's no differences like the one for the O-1A and O-1B. So it's anyone with extraordinary ability in the fields of sciences, arts, education, business, athletics. And the standard is that the individual is one of the small percentage who have risen to the top of the field of endeavors. So again, it is a pretty high standard. Usually, if you have evidence that you've met the O-1A, then you can definitely use that, leverage that information for the EB-1A. It is not a straight path from the O-1A to the EB-1A, but could help that you've already gathered some documentation for the O-1A, for the EB-1A green card category. So for the EB-1A, we usually would consider that someone would qualify if they have sustained national or international acclaim and that the achievements have been recognized in peers in the field, for example. For all these categories, you must show that you have you will continue or you will work in the area of your extraordinary ability. So that's usually something that might be an issue for some applicants depending on the field they're going to be working in. But in the application process, in the petition that you're going to file with the US Immigration Services, you will have to make sure that you will show your extraordinary ability will be used in your field because you're going to be working in that field and you're going to pursue an endeavor, you're going to work on a special project, for example, for an employer in the US, you were going to work on a movie, for example, or if it is extraordinary ability in the field of science, then maybe you're going to be an engineer for a company working on a very specific AI project, for example. So that's something that's common to the three categories there: the O1A, the O1B, and then the green card EB-1A. And then also a quick note here about national interest waiver. This is a very trendy topic in the immigration space, and that's something that Jiyae will definitely talk more about later on. But this is a category that we consider is sort of adjacent to extraordinary ability, and it is for people with elevated profile that maybe do not have the evidence to meet the standard for the EB-1A. And it is usually for people who are engaging in an endeavor of substantial merit and national importance to the US. So if you can meet the requirement for the EB2, because the national interest waiver green card is an EB2 green card, so different from an EB1A. And again, we'll go over that a little bit later on. But if you can meet that threshold for the EB2, which is at least a master's degree or higher, or you have exceptional ability, so it's not extraordinary ability, it's exceptional ability in your field of endeavor, and that you're also going to be engaging in an endeavor of substantial merit and national importance, then you are yourself well positioned to advance that endeavor, and it's going to be beneficial for the US to waive the requirement of a labor market test, because that's one of the requirements of the EB2. Then maybe you may qualify, for national interest waiver green card, and that could also be a good option. So if you believe that you have, some exceptional ability and you have the evidence to support it, but maybe not to the standard of the EB1A, because you need to have extraordinary ability and the standard is pretty high, in that case, the national interest waiver might be a good option. Again, if you are also meeting the threshold requirements for the EB2 classification. Jiyae, I don't know if you can hear me, but if so, if you can move on to slide 2, because we're gonna go over the O1A visa. Thank you. So O1A visa, as I was saying before, it's a very good option if you have extraordinary ability in the fields that were listed before: science, art, and athletics. We also have a very specific visa for athletes. I just want to mention it here. It's the P1, sort of a different category of extraordinary ability in the field of sports, but athletics can also be included in the O1A. So again, something to discuss with an attorney in terms of strategy. But for the O1A, you'll have to demonstrate either that you received a major internationally recognized award, such as a Nobel Prize, or, and this is not an and, it's an or, you have evidence of at least 3 of the following requirements or criteria that are listed here. So the more requirements and the more criteria that you can meet from that list, the better. But I will go over that a little bit later on as well, because there's some strategy involved with meeting all the requirements and providing all the evidence you have. Maybe that's not a good idea depending on the case. But if you have received the Nobel Prize, then it's going to be a pretty straightforward petition. If you have not received any award to that level, then you'll have to meet at least 3 of the following requirements. And I'm going to go into some of those, because we get questions about what evidence you would need to meet some of those. So receipt of a national or international recognized prizes. So this is a little bit similar to the first condition here, to have internationally recognized award, but this is for awards that may not be to the same standard as a Nobel Prize. So what usually applicants would try is to include all the awards that they got, all the prizes, including student awards as well. What we usually recommend is to not include everything. You want to make sure that what you are including in the petition and the awards that you're listing are actually relevant to the field. They are, well recognized in the field, and maybe a student awards about a master's thesis, maybe that's not going to raise to that level. And you don't want to dilute the evidence that you're going to provide, and maybe if you have 8 awards maybe 4 of them are not really that relevant, and they're going to probably confuse the officer. So maybe you want to focus on those 4 awards that are really relevant to the field and well recognized. So that's something to think about. And then second item here is a membership in associations in your field. So that's also something that people applying for O-1A usually believe that they meet because they have memberships in professional associations. But to be included, that membership must rely on being an association you can enter via membership, not only based on a fee. If you just have to pay a fee to be a member of an association, that usually would not be enough to qualify for an O-1A. You would need to, that membership would need to be based on recognition from peers, for example. So, as attorneys, we are members of associations and we pay an annual fee for that, but that would not work for an O-1A. It needs to be a professional association or organization based on recognition. And then you can see here there's a lot of information about articles that you may have published in your field, patents as well. That's very good to include if you've authored some patents. That's definitely something you want to include. And then if you've authored articles as well, peer-reviewed articles, very good evidence there. If articles have been published about you as well, about your achievements, that's definitely something you want to include. This is very strong evidence. If someone has written an article about your achievements in a professional newspaper or professional publication, then that's definitely something you want to include. And then in the STEM fields, and sciences, that's something that's usually included as well would be citations. So, if you are in the STEM field and you've published some articles, then you probably have a Google Scholar page with the citations, people citing your work in other works, and that's definitely something you want to include. A lot of citations would go along with an O-1A in the field. Other thing that people may consider would be to list the salary that they're going to get for the position in the US with the US employer. If you have a high salary compared to peers in the field and in the area you're going to work in, the geographical area, then that's something you can include as well. So very good evidence there. Anything that can show that you have those achievements and you have that extraordinary ability can be included. But again, there is sort of some strategy involved, and you don't want to include everything and sort of overwhelm the officer who's going to review. You want to focus on evidence that's strong and that actually is relevant for the field. Something that we usually include, for example, would be expert opinion letters from either experts who would know the applicant personally, or experts who are aware of the applicant's work. That's very good evidence as well, showing the achievements, showing that in the field other experts are aware of what you've done. Maybe it's a patent, maybe it's an article about a specific project that can be used, and we would quote the expert opinion letters in the letter of support for the petition. So all that is very good evidence. So again, if you want to go through the criteria and the requirements, we're going to share with you that PowerPoint, so you'll have some time to go through it. And then we can move on to the next slide, which is going to be about the O-1B. So I'm not going to go through all the criteria here, but again, you'll have access to the PowerPoint, so you can do it. But essentially, it's very similar. There is also either you have been nominated for or received significant national or international awards or prizes in the particular field. So we're listing here, Emmy or a Grammy or an Oscar. So that's all good to include, or you have at least 3 of the following. So as for the O-1A, you want to meet as many as possible. Minimum is 3 to get in. And you also want to make sure that those are relevant. So it's the same remark as for the O-1A, for the awards, for example. If you've played in a high school play, for example, and it was acclaimed, then that's all good, but maybe it will not be enough to qualify. It has to be something of national importance, and you want to have evidence backing that up. So O-1B could be a good option if you are in the field, because the standard is lower than O-1A, but you still have to meet those requirements. and provide strong supporting evidence for that. So Jiyae, if you can move on to slide 4 here, thank you. Just a quick reminder about the differences between the O1A and the O1B in the table here. So the fields, again, very different. The O1A is going to be for the sciences, education, business, or athletics, and then the O1B is for people in the fields of arts and motion picture or television industry. The standard is also different. As I was saying, it is stricter for the O1A. You have to be one of the small percentage of people who have risen to the very top of their field of endeavor in their profession. And for the O1B, standard is a little bit lower, but again, the evidence will have to support both standards, regardless of whether or not you apply for an O1A and an O1B. And again, I want to just focus here on whether or not apply for an O1A and an O1B. That's only possible if you are sort of in between fields, or if your field of endeavor would qualify yourself for both. As I was saying, if as a tattoo artist, for example, maybe you can be in the arts, but you can also be in business if you have a successful tattoo shop, for example. So that would be possible. But if you are in the field of science, for example, AI or machine learning, then the O1B will definitely not be an option. It's going to be an O1A. Duration of stay in the US is going to be the same for both. It's going to be an initial period of 3 years, and then you can extend from 1 to 3 years by increments of 1 to 3 years, and there's no set limit to renewing. But again, it is a non-immigrant visa, so you want to make sure that there is no issue with your intent in the US. This is not a green card. You cannot stay permanently on an O1A. And for the extensions, for both O1A and O1B, you have to provide evidence that the project you are working on and have been working on for the past 3 years will continue as well. Could be a different project, could be the same project that's been extended. If you are on an O1B, for example, and you have a band, then maybe it's a tour in the US. But if you're working in the technology space, maybe in AI, then you may have to prove that you have another project coming up with the employer, another AI project, tools, products, or service. So those extensions are a little bit tricky sometimes, depending on the field and what you're doing. You need to make sure that you have that project, you have all the evidence related to the continuing of the project or a new project. About families, whether or not spouses and children can come in the US to accompany you as dependents. If that's the case, they can. They're gonna have their own visas. However, just a quick note, because I know that's important for families, spouses cannot work in the US as dependent of O1. So that's something to consider. They will be able to attend school. Same for the children, dependent children. They can also attend school, but dependents of principals in O1 cannot work, unfortunately. We can move on to the next slide, which is going to be about the green card. So again, this is the EB-1A for extraordinary ability. It is a green card option for folks who would have extraordinary ability in their field, and the fields are all combined for the EB-1A. There is no separate category for art, so it's all in one. Same requirements or very similar as for the O1A and the O1B. And you have to provide very similar sets of evidence and as strong as evidence as you would need for an O1A. But there's something else for the EB-1A that would need to be taken into account. It's going to be the Kazarian analysis. So that's a very it's a little bit different than for the O1A. It's two-step analysis. And the first step here, as you can see, is USCIS, so the Immigration Services receiving the EB-1 petition, will examine the evidence to determine if you have either won a major internationally recognized award or whether you meet at least 3 of the EB-1A criteria as explained above. However, as we were mentioning here, simply meeting the EB-1A criteria will not be sufficient to establish that you qualify for an EB-1A green card. And the analysis will move on to step 2. USCIS will consider the quality of the evidence in the totality. So it is sort of a totality of circumstances situation, and it sort of ties back to what I was saying before about choosing the evidence that you're going to provide. You don't want to throw everything at the USCIS officer. you want to pick and choose the evidence that are, actually strongly supporting the case. So USCIS will take a look at the evidence, make sure that you meet at least 3 of the criteria, and then they will dig into the evidence to make sure that they are of sufficient quality to support that. So they're going to review everything, and they're going to take everything into consideration to determine whether or not the applicant qualifies. And as I was saying earlier about awards, so maybe you have gained 8 awards in your field, but maybe 4 of those were student related, or maybe not very prominent in the field. So maybe you don't want to include those, because USCIS will look at the awards and they will say, okay, that criterion is met, but then they will go through the awards themselves and determine whether or not they are relevant and strong enough to support that finding and that criterion. So you want to focus on evidence, again, that is strong and that is quality. That's why having expert opinions definitely, expert letters and expert opinion letters would definitely help, because you can, ask professor in the field. If you're in the field of science, for example, you can ask them to write a professional opinion about your achievements, and that would go a long way to in terms of the quality of the evidence. And then you would include evidence about that professor's credentials as well. So all that is very good. So be careful when choosing what evidence to include, because it might actually hurt your case if you're including too much and sort of confusing the officer with the amount of evidence that you're providing, and you want to sort of make sure that there's a good balance between quantity of evidence and quality of the evidence included. So you want to meet as many criteria as possible, but make sure that for each criterion that you're meeting, then the evidence is of quality. I think there was in terms of the presentation for extraordinary ability visas, the O-1A, the O-1B, and then the green card aspect of it. I will now turn in we will now discuss the NIW. I touched a little bit on earlier, but Jiyae will walk us through this category and the rest of the presentation.
All right, thank you so much, Hugues. And yeah, let's go over the EB-2 NIW, which is another green card option that allows self-petitioning. Now, the EB-1A green card that you just talked about in the previous slide is also a category that allows for self-petitioning of a green card, which means normally in other categories, you may need a US company to sponsor you with a US job offer. You may need that company to go through what is called a labor certification requirement. But if your profile fits the EB-1A, for example, you don't need a job offer. The foreign national themselves can drive the petition forward on their own. And the same goes with the EB-2 NIW, provided that you meet the criteria for the EB-2 NIW, you can drive your own petition forward without a job offer, without a US sponsor. So let's go through the eligibility requirements. So the first thing to consider is, do you meet the threshold requirement for the EB-2 category as a whole? And now note that the EB-2 NIW is a subset of the broader EB-2 employment-based immigrant visa category. And the broader category, so the threshold requirement would apply either if you were, using a U.S. sponsor to, get you a job offer and go through labor certification, or if you were, trying to qualify under the EB-2 NIW, the threshold category, the threshold requirement would apply regardless. So how do you meet the threshold requirement? You either need to show that you have an advanced degree, which is defined as a master's degree or higher. So for example, a PhD would apply, or even if, you have a degree like an MD, a medical doctor, or a JD, a Juris Doctor degree, that will still qualify as a master's level or higher, because you typically need to have a bachelor's degree to gain admission to those types of programs. Now, if you don't have a master's degree in your field, but if you have a bachelor's degree in your field and 5 or more years of progressive work experience following your attainment of that bachelor's degree, you may be able to use that to qualify as the equivalent of a master's degree holder, the equivalent of an advanced degree holder. Now, note the word progressive. So not all work experience would qualify as progressive work experience that will get you to the master's equivalent. Progressive means the duties that you performed in your particular job changed over time to include more senior, more complex duties. Similarly, you can show an upward trend of your salary. You can show an upward change in your job title, such as you start as a junior associate and then you become a senior associate and then a partner, for example. That kind of trajectory can show that you have been responsible for more complex and senior duties as time went on. And it's that kind of projection, that kind of trajectory that the government is looking for when they're assessing if you have progressive work experience. And that will typically be proven through employment confirmation letters from your previous employers, both, confirming that you have the requisite 5 years of experience and also how your duties changed over time. Now, if you don't have a bachelor's, if you don't have a master's, if you don't have, the equivalent work experience, there is another way, an alternative pathway you can qualify for the EB-2 category. And that is by showing that you have exceptional ability in the sciences, arts, or business. And to show that you have exceptional ability, you must meet at least 3 of the 7 criteria. And as a holistic matter, the evidence must show that you are someone who is operating at a level that is, quote unquote, significantly above what is ordinarily encountered in your field. So there is kind of a 2-step analysis there. So the evidence must both, meet at least 3 of the enumerated criteria here, and also as a holistic matter, tend to paint a picture of someone who is at that level. Now, it is definitely a lower standard than the extraordinary ability criteria that we have been talking about in the context of the EB-1A. So the EB-1A, they look for, someone who has reached the very, very top of their field, such that, you're one of the small percentage that has reached the very top. But for exceptional ability, they're not looking for, that level. You only need to show that you are someone who is operating at a level significantly above what is ordinarily encountered. So what are the 7 criteria? Those include things like, any diploma that is relevant in your field. If you have a license, you can also show that. You can show 10 years of full-time experience in your field. High salary, that is another criterion you can use. And importantly, you can prove a variety of ways that you have received recognition for your significant contributions to the field, by your peers, by government agencies, by professional associations. And this can take a variety of forms. You can, present awards that you've won, for example. You can present, copies of patents you have authored. That also shows that you have been active in, advancing the field. You can, provide copies of publications that you've authored in a journal. You can provide copies of media articles featuring you. If you've, appeared in industry podcasts, for example, you can really be creative with the types of evidence you can use to prove that you have received such recognition. And expert letters, as we have been discussing in earlier slides, can also play a big role in contextualizing to the USCIS officer what those recognitions were for. So let's say that then either through exceptional ability or through advanced degree, you meet the EB-2 criteria. Now, that is not the end all be all. There is still the challenge of proving that you yourself meet the qualifications for a national interest waiver. And the reason why this is important is because normally, beneficiaries who meet the EB-2 category, they're expected to go through the standard labor certification requirement. And it is kind of a challenging requirement and takes a long time. And it requires that you have a US job offer. It requires that, you have an employer that is willing to take the time and effort to sponsor you. Now, the NIW, the National Interest Waiver, is a privilege that exempts you from those onerous requirements and consequently allows you to just drive forward this petition without going through that time-consuming labor certification process. So you do need to show the government that you meet that preferential treatment, right? The national interest waiver, which is a privilege. And in order to show that, you need to provide evidence under the 3-prong matter of Danaher criteria. And here are the criteria. The first criteria is you need to prove that your proposed endeavor in the United States has both substantial merit and national importance. And what does that really mean? So substantial merit and national importance can be proven in a wide variety of fields, including business, including health, education, science, technology, and even culture. And endeavors that tend to further human knowledge in those key areas, such as medical advances, civil engineering, for example, improving practices in your particular industry, those types of endeavors are likely to qualify as endeavors of substantial merit and national importance. Now, a strong economic impact potential could be helpful for substantial merit and national importance. For example, if you are developing a new type of technology in the field that can significantly increase the efficiency of certain manufacturing methods, such that, your innovation could be published in patents and other companies could license that and also use that to enhance their practices. Those types of things are considered to have a broad impact that has a national level significance. Even if it's a niche field that you're advancing, if your endeavor has, the potential to advance the field more broadly and not just benefit your immediate company or your immediate clients, then that can be considered as an endeavor of national importance. Now, one thing that could be helpful is to tie it with, government pronouncements of what are some policy priorities of the United States. So, for example, if the current administration has promulgated executive orders or other types of government action to advance environmental sustainability and, to fight climate change, those things. If you can show that your endeavor has a substantial potential to significantly advance those priorities, you can combine the evidence with such, government pronouncements, such as government reports, executive orders, and things like that, to convince the government why your proposed endeavor actually does have national importance and goes beyond just benefiting your immediate employer or clients. Now, the second requirement is that showing that you yourself are well positioned to advance the proposed endeavor. And for this inquiry, the focus is on the individual. So you will provide evidence regarding your past work in the field. You can provide evidence of your relevant education. You can provide evidence, kind of a portfolio of previous projects that you've done that is related to your proposed endeavor that can convince the government that you do have the specific know-how and skills to successfully bring forward that endeavor of national importance. So really the focus is on your previous work. And this is why the NIW can have a synergy with the extraordinary ability, petitions, because if you can show that you have done outstanding work in your field that is substantially above what is ordinarily encountered, you can use that kinds of previous achievements to support the fact that you're well positioned to continue to do this impactful work in your field. Now, the third prong is that there must be a showing that on balance, it would be beneficial to the United States to waive the requirements of a job offer and thus of a labor certification. And this goes to what I've been saying before, that the default for, an EB-2 green card under employment is to get that job offer, to get that employer to test the US labor market to see if there is any other US worker who can fill this job. Now, you can prove a variety of ways that no, you cannot, do that, because either the benefits that you bring to the table are so broad that it outweighs the ordinary benefits of saving one job for a US worker, or that you have very specific and unique skills and know-how that cannot easily be replaced with, just another worker with minimum credentials, because that's a requirement for labor certification. You can also, if you're an entrepreneur, you can talk about the US job creation benefits. For example, if you're running a business and you project to be hiring a high number of jobs in an economically depressed area, evidently, giving the NIW to you and giving you that opportunity to run that business will create more jobs than, the ordinary benefits of saving one, professional spot for a US worker. So there are a variety of arguments you can use to support that third prong. And note that all three prongs need to be met in order for the petition to merit a national interest waiver. So you can't fail the first or second prong and just go with the third prong. You do need to meet all three prongs to be approved for a green card under this program. All right, so for the next topic, let's talk a little bit about expert opinion letters, which is a very important element in those types of petitions that deal with extraordinary ability individuals, and also a very important part of EB2 NIW petition. So the expert letters for those petitions have slightly different purposes. So for the EB-1, EB-1A, and the O-1 petitions, for example, the purpose of the expert letters is really to confirm that you have extraordinary ability in the field and have received that, national or international acclaim as someone who is outstanding in the field. Now, you can use expert letters to support the narrative in a variety of criteria. For example, if you're trying to prove that you have played a critical role in a distinguished organization, for example, you can have someone who is currently active in a senior position at that particular distinguished organization provide an expert letter that confirms that you have played that critical role, and importantly, develop a specific and concrete narrative of what role you played. Why was it critical to the success of the organization? And why does it prove that you have extraordinary ability? Why couldn't this be done by any other person, with, minimum credentials or, the ordinary credentials? So these expert letters really play a big role in contextualizing the evidence, the objective evidence for the USCIS officer to really be, persuaded that you meet the evidentiary criteria, and also that in support of the Kazarian analysis, that you are indeed one of the small percentage of individuals who have reached the very top of their field. With regards to the NIW letters, there are a couple of different functions the NIW expert letters can play. The first function could be to confirm the national importance of the proposed endeavor, such as a letter from a government agency, for example, can be very compelling for that regard. The government agency official can talk about the limitations in the industry or the field and why this is important for, a particular endeavor to, come in and solve these limitations such that the industry can really move forward. And why is that important to the national interest? Those types of arguments can be very persuasively developed with a letter from a government agency official. Another type of an NIW letter can be for the purpose of supporting the second prong, that the individual is well positioned to drive forward the endeavor. So those types of letters can talk about an applicant's previous work in the field, the applicant's contributions to the industry that happened in the past, and link that with how that makes them well positioned to advance the endeavor. Also, such letters can talk about the unique skills and irreplaceable expertise that the person has that would not be easily be replaceable with someone with minimum credentials in the United States. Finally, another type of letter that could help an NIW petition, especially if you are an entrepreneur, is you can get a letter from an economist who can really focus on the projected economic impact of your particular business project in the United States. It can be in terms of job creation, it can be in terms of economic output and induced, economic productivity that can benefit the region more broadly. Induced job creation and implied job creation is also a thing. If you develop, a high level of economic activity in an area, more jobs will be created beyond the jobs that you're directly creating with your business. So an economist report can really help amplify this narrative of substantial positive economic impact. Right, so let's talk a little bit about who you would ask to write such an expert letter. So the question is to really recruit leading experts in the field who typically have decades of experience. And we would recommend adding a copy of the full curriculum vitae of each expert who provides the letter, just to, boost the credibility of the letter. And the USCIS officer will really, be more willing to accept such a professional assessment from someone who has that leading stature in the industry. We would also recommend having a mix of independent and inner circle letters, what I call them. Independent letters are people who don't know you personally, but they know you through your reputation in the field or through, your activity in the professional network. They can provide a little bit more objective account of the merits and caliber of your work in the field. Now, by contrast, inner circle letters from people who have worked with you in the past can really be powerful in contextualizing your previous achievements. And I did mention, as an example, when you're trying to prove that you played a critical role in a distinguished organization, definitely it will be a good idea to get someone that you've worked with who is at a senior level at that organization, provide that confirmation letter, talking about why your work was important, why does that, really push you to the level of someone who is extraordinary in your field. And lastly, for the NIW, if you can get a letter of support from a government affiliated official, that could really go a long way in supporting the merits of your petition with regards to proving national importance, due to the nature of the petition. So, how does the individual know you? And as I mentioned a minute ago, it's good to have a mix of independent letters and inner circle letters. They can serve different purposes. And finally, what will be the content of such expert letters? A discussion of your work, recognitions, accomplishments, achievements. Really, it is important to go into the concrete details of how and why your previous work set you apart from others in the context of extraordinary ability. Why are the achievements important? What are your contributions to the field? And in the context of NIW, it will be very important to provide a discussion of the expected prospective impact of your work and how this can benefit the field more broadly as opposed to benefiting just your employer or your clients. All right, so then let's talk a little bit about some strategic considerations that can be relevant to choosing which category you should apply for. We discussed a variety of categories, the EB-1A, the EB-2 NIW, and the O-1 visas. Now, the first question to ask is, do you want to stay in the United States temporarily or permanently? And as we mentioned before, the O-1A and O-1B are non-immigrant visas. They're well suited if your work in the United States will be temporary. Now, one thing to note is that there is no lifetime limit to how long you can stay on the O-1. You can continue to extend your O-1 provided that you can continue to have US-based work in your area of extraordinary ability. So there is no 6-year limit. There is no 7-year limit like as in H-1B or other categories. Now, the EB-1A and NIW are both green card categories, and they are well suited for people who do want to live and work in the United States permanently. And although the O-1A and O-1B, they will be tied to a particular employer or agent, the one who petitions the visa. If you get the green card, you really do have the freedom to work with any organization you want, and also you do have the freedom to just not work. So, if you are in the United States for longer than a particular period of time, you will also normally get the option to apply for U.S. citizenship. So if that is one of your goals, the EB-1A NIW green cards could be a great option for you. Now, on the flip side, there are some requirements imposed on green card holders, right? So, for example, there's a limitation on how long you can stay outside the United States if you are a green card holder. So if you are someone who needs to really have this freedom to, stay for a longer time in your home country, for example, the EB-1A and NIW green cards may not be the best option for you. The other question to ask is, do you have a U.S. employer or agent, or do you want to self-petition? Now, for the O-1 visa categories, technically, you're not allowed to self-petition, which means the foreign national themselves are not able to drive forward the petition as the petitioner. Now, however, the O-1 is flexible in a way that if you are an entrepreneur, and let's say you found a new entity in the United States, let's say you're the owner of a new company that you set up in the United States, and even if you have ownership interest in that US company, that U.S. company is considered a separate legal entity from you, and that U.S. entity can be the petitioner for your O-1 case that drives forward the petition. And that is an important distinction because that gives you the flexibility to use the O-1 as opposed to, other categories that may be more strict with respect to ownership requirements. You can also file the O-1 petition through an agent, a U.S. citizen who is an agent. And this does not need to be someone who is in the, business of being an agent, but it can also be your acquaintance, for example. You just need to be able to provide contracts or other reliable evidence that you do have work lined up in your field, such that you will disclose who you will actually be working for when you file this petition. Now, those types of strategies can get quite complicated, so make sure to get the advice of a lawyer to look at your particular case before taking action. There can be nuances to take note of. With regards to the EB-1A and NIW, both are green card options that allow the applicant themselves to self-petition. So there is no limitation. There is no U.S. petitioner that's needed. You yourself, as the foreign national, can drive forward your case, which can be a significant advantage. Family considerations. So as Hugues mentioned before, for the O-1, your spouse and minor children can join you in the United States on O-3 visas, and they can study while they're here, but they cannot work. For the EB-1A and NIW, both are green card options, and once you are approved for a green card, your spouse and children also have the option to apply for green cards, provided they meet the requirements. For example, your children will age out when they're 21, and they can't be married and things like that. But they do have the right to also become green card holders, so that can be a significant advantage. All right, considerations when moving from a non-immigrant visa to a green card. I'll go through this quickly because we only have 5 more minutes. With regards to qualifications, it is very important that even though the regulatory language is phrased very similarly, when USCIS is looking at an EB-1A petition, they're looking at it with a very, very strict eye. So as opposed to the O-1A and O-1B even, the O-1B has an even lower standard. Getting approved for the O-1A does not mean that you're automatically approved for the EB-1A just because the quality of the evidence that they're looking for is so high, even if the regulatory requirements are similarly phrased. So definitely seek the advice of a skilled lawyer if you want to gauge your chances at the EB-1A. It could be one strategy to get the O-1 first, and then once you're in the United States, continue working on building your profile and collecting the types of strong evidence that could build a good EB-1A case while you're here. So that can be a good strategy for many people. Timing. Consider how much time is left on your current underlying visa. For example, if you're on a TN visa, which is one visa that really scrutinizes strictly for non-immigrant intent. Once you file an I-140, which is the underlying petition for a green card under the EB-2 NIW or an EB-1A, it could be harder for you to renew or extend your TN once you have that evidence that you applied for a green card. So maybe definitely talk with your lawyer. It could be a better strategy to extend or renew your TN first and then apply for the I-140 to avoid any problems at the border. Finally, for family considerations, since there is that 21-year threshold for children aging out, consider filing for the green card early to avoid any issues with that. So some advanced planning may provide some benefits there. All right, so final slide. Are extraordinary ability categories available for entrepreneurs? And the answer is yes. The EB-1A and NIW both allow for self-petitioning, which makes it a very attractive category for entrepreneurs who may not be able to secure a U.S. job offer from an outside employer. Changes in the NIW standard made under matter of Denisar, which came down in 2016, explicitly mention that the NIW could be a category suited for entrepreneurs. So really this opened up to a greater degree the option for entrepreneurs to get a green card under the NIW program. It is also possible to apply for an O-1A visa as an entrepreneur, as someone with an extraordinary ability in business, if you have, if you do meet the evidentiary requirements that Hugues went through earlier. But note that you cannot self-petition, right? So you do still need to have this separate U.S. corporate entity that can act as the petitioner. If you're, thinking of going through that route, please make sure to talk with a lawyer who's experienced in that, as there are some nuances that would need to be figured out. All right, so I think we are done here. Let's see if we have any questions.
Yeah, just have one question. And it's actually very, it's related to the last slide here. It's a question whether we can go, through the step-by-step process to apply from an F1 visa to an O-1 visa. So we won't be able to go through the step-by-step. You may want to schedule a consultation with our team to do that. But it is possible, to change status within the US from an F1 visa to other categories. There are some specific considerations that would need to be, reviewed by an attorney and yourself. And for O-1 specifically, I would say that, for a recent graduate, some considerations are to be taken into account. And I think we went over that, strong evidence. And if you've recently graduated, maybe, you have, you won't be able to gather as much strong evidence as you would need for past achievements, but it is completely possible. You want to do that analysis about quantity and quality of the evidence. And then the other part of the question was about, starting an LLC and maybe get a visa through that. And we went over that over the last slide. Jiyae, you went through the process of applying as an entrepreneur. So I think that would answer the question. And I don't see any more questions.
Great. So we can close here. Thank you, everyone, for your participation. Thank you, Hugues, for sharing your expertise. And I hope everyone has a great day. Thanks so much for joining us today.
Thank you. Bye-bye.
Bye.